by an appeal made by Blore Homes and Paul and Linda Buckingham against the decision of Basildon Borough Council to refuse planning permission for a full application for residential development of 269 dwellings, use class C3, 2 times vehicular access points off Dunton Road, formal and informal open space, hard and soft landscaping, including acoustic barrier and associated infrastructure. Usual reminders, please, all mobile phones turned off or switched to silent. We've concluded the cases now on behalf of the local authority, the appellant and the Rule 6, and we will now be having the remainder of the inquiry will proceed on the basis of a round table sessions covering conditions this morning and returning on Tuesday to conduct the session on the section 106 and hear the closing submissions on behalf of the parties. Just on that, can I just check on the 106 that I've had? Is that different from the one that was submitted?
It is slightly, and indeed there's going to be one more change that's coming your way as a consequence of the note that I've put in and the discussions that we've been having. So it is slightly different. I don't know what the nature of the difference is. The one that was submitted. Have a check. We'll come back to you on what the difference is. On the thing that's being worked on by, I think it's actually by the council at the moment. So we're waiting to hear, it is to do with this point about the red and the blue line, because at the moment, as we've picked up on, or as has been mentioned during the evidence, the red line is the red line. But in order to make sure that the western boundary treatment works, we're going to need to put in a 106 plan that includes the entirety of that area of that's outside the red line, and have some provisions for that in the 106. That's being drafted up at the moment by the council. So it's good that we've got the weekend in a way, but I don't know whether it'll be done today or not. But that's the intention is that the western boundary treatment, to the extent it falls outside the red line, will be controlled through the 106, which will require a plan and some words. So that's what's happening at the moment.
Were the council aware of that?
The council are doing it, I think.
Were you aware of that beforehand?
Oh, sorry. Understanding that they're doing. I'm not directly engaged with it. And that was. Oh, sorry. Yeah, of course. Just before the thing that's changed, sorry, is to do with highways contributions, because or highways matters, because originally there was an approach to us making a contribution to highways works that were going to be identified and undertaken by Essex. But now, in the version that you've got now, there's a 278 arrangement whereby the works are specified and to be undertaken. So it's not a contribution.
Okay,
that's the difference.
Right. Okay, that makes sense.
That was the difference from the one that you'd previously received.
Okay.
Exactly. Yeah, the cycling and walking. Exactly. That's what I was trying to say. Initially, it was a contribution towards cycling and walking, and now it's actually works. You want to turn your microphone on? Oh, right. Okay. Yeah, so that was the key difference from the one that you'd had previously, and now there will be, by the sounds of it, one more change.
Yeah, it's all been agreed, and I think that final drafting's done. Yeah.
Okay, because can somebody respond to my question about were the local authority aware that land was required outside of the application site boundary to deliver the landscaping scheme?
The council dealt with the planning application in line with the allocation that was in the withdrawn plan. So that land wasn't, at the time we were dealing with the application, wasn't deemed to be necessary for the application to come forward. So we dealt with what they submitted to the council, which was the land originally outlined in red. No, yeah. So it's a benefit to the development, I would say.
Okay, let's just look at the plan so I'm clear as to what you're talking about. So there's obviously a site plan to still come with the 106 as well. That's not included in that bunch of plans that you gave me.
Right.
That plan will be amended to show what we call the additional land will be hatched. So the 106 agreement will be the red line of the planning application, and then the additional land, which is subject to the one, will be subject to 106 agreement to be delivered as open space and landscaping, will be hatched, because obviously it doesn't form part of the planning application and will be dealt with being delivered as part of the 106 agreement. And that additional clause has been added to the 106 agreement and the new plan.
Super. Has that been done, or is it being done?
It was done last night, so it should be with your lawyers.
Oh, right. Okay. We'll check. Thank you.
So just
sorry.
Can somebody just direct me to the landscaping plan we're talking about? Ten 10.3.2, did you say page 7? Yeah. 'Right, so that's the site layout plan. Which bit are you talking about? That's
the western area.
You'll see, madam, that there's bits of landscaping and open space on this plan which fall either right on the edge of, but then also just outside.
So the bit fronting Dunton Road, is that's like a
there's a bit that fronts Dunton Road,
dog leg, and then comes back into the farm,
and then indeed also the thin strip then that runs all the way down from there to the other side to the A127 end as well.
Have you got a plan that's not a coloured up one, so I can actually see the?
Yeah, we need to print it and circulate it, but it needs to be, I think, a simple sort of red line, blue line, or something like that. Is that what you have in mind? A red line, blue line? It is.
Well, you do the 106 how you see fit, but just for me, have you got where's this layout that's not coloured up so you can see the see it's a bit, on like an OS space, if you see what I know. This is on an OS space, but it's you must have it as a
yes.
Just a sort of general site arrangement or something plan.
Let me have a look. I think the answer is that we're going to have to do that this morning. So we've got one that's
there's a CD 129 one, but that's
that only
landscaping plan which doesn't include that area with the red line.
Yeah, so we've got exactly. So we don't actually have CD 129 is everything within the red line, but it simply shows white land outside the red line, and that's the issue that we're trying to correct.
This is when I need the 2 screens.
suppose if, yeah, CD 129 is maybe helpful to see what the starting point is almost, but we do need another plan, at least one more plan. So yeah, so by comparing 1.29 to the
Yeah, my ability to compare when I'm
yeah,
clicking.
it's understandable.
Yeah, it's not.
Yeah, I've got the so I haven't looked through it either.
You send it, we can then.
Yeah.
The council have helpfully, well, there is another plan that we've not yet got, but the council have produced that is a version of the one that you've been taking to Mr. Child's evidence, but shades all of the extra the bits outside the red line in blue. So that's what they are.
Right.
Working.
So yeah, I'm looking at. I think it's just the general arrangement plan. It's the
Is that
site general arrangement ends 001 brackets P2.
let me see?
CD12A, is that the one you
CD
just said?
128. Certainly look at that one.
Yeah.
Yeah. What we yes. On the landscaping proposal plan, which obviously shows a similar thing, is at similar red line is at 1.29, but obviously the red line's the same.
Just have a look at that one. So yeah, 129 excludes that area, doesn't it?
Exactly. Yeah. So the point is that we need. I think what we're saying is that what we haven't yet got, or at least I think the council have to be fair prepared, but what we've not yet got to hand into you is something a bit like this, but that shows everything.
So I need to check this, but the landscaping so this is a conditioned plan. The landscaping condition, what does that refer to, a specific plan?
So we're proposing Mr. Spector, we're proposing a new schedule into the 106 agreement to do with the western boundary.
Yeah.
So it'll be done via a clause, a whole new clause, the 106 agreement. They'll basically then deal with that site through Schedule 10, a new Schedule 10 in the planning obligation.
Yeah.
So obviously, so it'll be dealt with in that, and that's what the appellants haven't seen yet, is that new Schedule 10.
Just received it, but we'll obviously have
so this the condition as, I mean, we'll get to it in a minute, but the condition as proposed, just on conditions, not what you're doing with the 106.
Yeah.
It refers to this as the landscaping plan, does it? Or is it just this isn't approved?
It will just deal with the area outlined in red on the visual planning application and not the new additional land.
Okay.
Yes, so those are all approved plans in accordance with condition 2, aren't they?
We'll get to it when you come to it, but I can't remember how, if the landscaping condition.
There is then a length at 16.
Pardon?
So there's a length condition at 16.
Yeah. Okay, well, when we get to that one, we need to work out how that's going to work with the land that's
That's to the
outside
west. Yeah.
of the. And therefore, I think that will then become clear as to what needs to be covered in the clause. Isn't it?
Yes.
So section 106, there's a site plan to come. I'm going to leave with today. Yeah.
Sounds like it.
And that one's slightly different. So, oh, and Mr. Chard, is he attending the site visit?
Yeah, he is.
Yeah.
So I don't know where he's. He is attending. Yeah.
Okay, I'll just, can I use his A3 version of the
Sure,
coloured
you
up
can.
plan? Can
Yeah.
you make sure he brings that?
Yeah.
And
Is it A3 version of which plan? Sorry.
the one that you first referred me to. The one,
in his proof.
Yeah.
I'm sure he's got that. Yeah.
that's just going to be helpful in terms of the site visit.
Yes, of course.
I should mention, don't nobody at the council take down the core, whoever's set that up, the core documents list. I have had it before where it gets taken down. Or, yeah, no, don't disappear. So it does make things quite difficult. Right, so the way this session works is it's a lot more informal than the rest of the proceedings that we've had. You just input any comments as you see fit, and I go through the conditions and talk through them, and any clarification points of clarification you need, then just let me know. So you've got a list of the, yeah, okay. Yeah. Oh, brilliant. Yes, I was thinking about those. Thank you. Yes, please. Yeah.
While those are being handed out, obviously, I know I've not mentioned it.
Yes, sorry. Do you want to just talk
of course,
through that?
yeah. Just very, very briefly, just on because of something that came up yesterday, we've just clarified why the red line was as it originally was, and indeed why it didn't show a wider blue line. And the answer is, as I'd anticipated, it's to do with the relationship between Blore, who currently instructs me, and the landowners, and the nature of Blore's control of the land, because originally at the time the planning application was put in, Blore's control extended to the red line. It now extends a bit wider, hence we're having these conversations about blue lines and 106 agreements.
Right.
But that explains the position as at the time of the planning application.
Yeah, so that doesn't change anything in terms of the 106.
It doesn't change anything in terms of the 106. No, it's just for full context.
Okay, thank you very much. Okay, so I've got to hand the conditions as suggested, the ones within the statement of common ground with the Highways Authority. Can I just clarify, are these Basildon standard conditions, or have these been worked up?
We don't have standard conditions. These are conditions that we've sort of over the time dealing with major applications we've put together. So they're standard as such, but not overly. We haven't got a standard book of conditions at the moment.
Okay.
No.
That's fine. Thanks for clarifying. So the first one is standard in terms of the time limit. I don't have any comments on that. Number 2 is setting out the relevant plans. And I don't have any comments on those. Three is the land contamination condition. I don't have any comment on that. That requires the written method statement and implementation of any approved remediation scheme is addressed by condition 4. I don't have any comments on that. Condition 5 is the construction environmental management plan, site waste management plan, and construction logistics plan requirements. And those specified measures are set out on the following page. I don't have any comments on those. Following on from that, condition 6 is dealing with construction noise. And referring to the relevance.
Inspector, we consider that to be a repeat. We could actually technically remove that one.
Okay.
Because that one is covered, but within the condition above it, it's covered by little 7. So you could actually remove that one.
Okay, the only issue with doing that is then, unless you want to amend conditions little 7 to include the reference to the British standards.
That would make more sense, really. So it would be covered under one condition. Yeah.
So the sentence, the works are to be carried out in accordance with, that would then go on to little 7. Is that what you mean? Yeah.
Would you like us to be drawing up a revise, or
No.
are you going to do this yourself?
No. Okay, noted that. Condition 7, tree protection. In relation to the existing trees. Parts A and B, I'm content with on those. Badgers, can you just talk me through condition 8 and how that relates to the representations, the statutory consultee comment? Is that in accordance with what they were requiring?
This condition has come from requirement by the Badger Protection Group. I mean, just speaking earlier to the appellants about this, and apparently this is they've seen a similar condition used on a site in Rochford, so it must be a standard condition that the group are using now.
Okay. Okay, part D is I'm concerned about the enforceability of that and whether it's precise enough.
This is 8A. Oh no, 8D. Sorry, yeah, 8D.
How would you be enforcing that?
I mean, to be honest, E's not great either.
Sorry?
E's not great either from that point of view. Storing things in a way that you can't be knocked over by roaming badgers. I don't know what that means.
Okay, well, F, you've got a subsequent condition that deals with fires, so that's...
I think H is also not precise. And then I do wonder if, I mean, got no objection to the principle of something like this, but by trying to go into this much detail, they've inevitably brought in matters that just can't. I mean, I understand where they're coming from, but you just can't cover these sort. Not, I mean, some of these things just don't work in a condition.
So could we change D then to the storage of topsoil or the soft materials on the site should be subject to daily inspections before work commences?
Sorry, by whom?
Pardon?
Who's going to be
Oh,
inspecting?
sorry, D. Perhaps.
No, who's going to be inspecting?
I mean, it's just it. They are very subjective, aren't they? They are, but
Yeah.
they're very arbitrary.
Would it be more of a way of changing it to a scheme to be submitted or something, rather than trying to go into this detail in a condition? I mean, almost the problem comes from the sub-paragraphs, really.
Yeah.
So, you know, before the sub-paragraphs, it begins prior to commencement, ... Measures to protect must be implemented and retained. Couldn't it be, is this too high level? Could it be measures to be agreed, you know, to be submitted and approved sort of thing? Should be approved, and then thereafter, you know, whatever, and then all of that detail could be taken out of here and then put into the measures that are agreed.
Mr. Hardis is also suggesting the same, that
Yeah.
it should be a plan. I mean, because for example, on D, when you could say the storage of topsoil or other materials should be subject to daily inspections, and the bit in the middle seems to be more like a reason
Yeah.
to me.
Yeah.
Definitely.
Okay, that would be a potential way forward. The measures shall.
I mean, there's no objection to the principle of something like this, but I don't think this wording works.
I think it might be worth using some of these sub-bullets through to J as kind of short headings as to matters to be included with the management plan to be approved. I'm not saying that level of detail, but including, you know, so that make sure that the management plan addresses all the matters of concern.
Yeah, I mean, if it's helpful, a lot of these matters are set out in the ecological technical note that SES prepared. So it's something that we're perfectly comfortable with because we've seen it through our own report in any event. So we would have no problem with that.
I mean, the advantage of a management plan is it then can include consulting with the Badger group who've got the specialist knowledge to say this is an adequate plan or not.
Sorry, isn't there a requirement for an ecological clerk of works through this process in terms of doing the monitoring? In terms of who would be checking, presumably it would be the ecological clerk of works.
Yeah, I think the enforceability of the wording that's used here is not going to work. It wouldn't work. So I think the possible way forward would be to have something along the lines of the measures are to be covered, shall be submitted and approved by the local planning authority, and then the councillor retaining control over that.
Also, it needs to be two conditions, because there's actually two conditions here. One is with regard to the licenses, and then you've got a second one that deals with development on the site. So actually, you've actually got two conditions merged into one here. The first condition runs from no works, including groundworks, down to accordance with the license is one condition. Then the second condition is prior to commencement of any development, including groundworks. So that we've actually got two conditions merged here as well, because you can't technically then discharge any of those conditions until both are dealt with. So it would actually make it impossible to discharge that condition as a whole anyway. Condition 8 would never be discharged. So it needs to be either 8A and 8B or 8 and 9. Okay.
At the end of the first one, the end of A, there's an Is that one of the tail pieces that the council
Yeah,
is
that needs to come
concerned
out.
about?
Yeah,
That comes out.
so it would end up any badges that are certified shall be protected. So should be protected in accordance with the license. Full stop. And then the next condition is prior to any commencement, a management plan should be submitted dealing with measures to protect badgers from and then this should be agreed with the relevant ecology group and the council prior.
Just on the wording of that, Christine, so that would be the scheme would be to be submitted and agreed in writing by the local planning authority. You would talk to the badger group as appropriate, but
In consultation with the relevant, I'd use the relevant ecological group, because obviously we don't know, it might change, isn't it, between.
Absolutely.
Yeah, so
but it would be for you to sign it off effectively as a local
yeah.
planning authority. That's the key thing.
I'm reading these, and I'm reading these of slightly more informatives rather than, because the requirements are set out now that you've helpfully said it is 2 conditions merged into one. The requirements of what would be permitted are going to be set out by 8 under the terms of the license, aren't they? I'm just going to pull up the original representation from them.
I've also spotted a further problem, I think, ma'am.
Yeah.
In the first paragraph, it got a dreaded tail piece, or as otherwise agreed in writing by the local planning authority. I think would have to come out in any event.
Oh, the middle bit.
Yes.
Yeah, I think yes, you do. Yeah. Sorry, I just need to find the original consultation letter.
Ma'am, just going back to your point about whether you think this is 1 or 2 conditions, my reading of it would be that it is 2 conditions, because the license is concerned with activities or permission to do works to sets in immediate vicinity, whereas the second part about the management plan is a broader issue about, in effect, almost like protecting badgers as they're roaming in the wider area on the construction site. And I think there's slightly different points.
Yeah. So then, isn't that covered by the management plan that's going to be submitted in terms of? Yeah.
I think it can be. It's just whether or not you get that level. I mean, it should be. It just means that the ecology management plan is actually quite complex, and whether it's better to split them just to make things absolutely clear.
Okay, they've listed it out as bullet points, haven't they? They haven't set it out as a condition. Right, so yeah, so condition 12 as drafted is the ecological appraisal actions. That includes the appointment of an appropriately competent person to provide on-site ecological expertise during construction.
And then there's a LEMP, which obviously includes ecological management as well, which is 16.
16.
It's all pretty high level at the moment, but obviously if we wanted to add some limbs to that LEMP, that could be done.
The practical ecology document version 6 there, I think there's an updated version that we'll just need to insert the version 7.
On which bit, sorry?
12.
Yeah, which part of 12?
Forgive me, the reference to the preliminary ecological appraisal, practical ecology version 6, May 2020. There's an updated version that was done.
Okay. So what should that
the
be?
application. So I think it's
7.
now version
Version
7. Yeah.
I think it's April 2023, but let me just 100% check.
Hi, Mum. Just to let you know, I believe the LEMP condition came from colleagues at Place Services, so I will contact them now to see if some of those measures can be incorporated into the LEMP.
Okay, well, you can contact them if you like. I don't think
I mean, we can do, you know.
Yeah, I think they, yeah. Like you, yeah, we're jumping ahead of ourselves, but this may include was not precise enough on that one. So this should include, or may is a bit
yeah, too vague.
Okay. So I'll have a reflection on A2J in light of the representation received, and I've taken the comments away. As to whether a possible way forward would be that 12 would be amended. So we'll look at the wording of that when we come to it. Okay, so 9. Details of materials, including samples. I don't have any comments on that. 10 is a site levels. 11 deals with surface water drainage. And 12 is the ecological appraisal actions. Do you have the
February 23.
So sorry, when was that submitted? Has that been submitted to the council then?
It was submitted when we resubmitted the application amendments ahead of determination.
Oh, okay.
When the application was updated effectively. Part of that pack.
Okay. Lighting design as set out in this, how does that relate to the subsequent lighting condition that's been put forward?
It's a duplication.
Yeah. So you wouldn't, can you just remind me of the lighting condition? Oh, 21. Okay. Yeah. Is that a separate thing, wildlife sensitive lighting?
That we picked up in the wildlife centre, it should be picked up in your ecological appraisal actions, because that means that you would then deal with lighting as part of that design. So I think actually it is a duplication of those.
Okay.
It says all mitigation enhancement measures shall be carried out in accordance with details contained. So I think
And those are already set out within. Yeah. Okay.
And whether you consider that 21 deals with other lighting, I don't know.
Well, I wasn't sure if that was lighting, sort of street lighting, and
that would be all light. All lighting needs to be ecologically sensitive, doesn't it? So I suppose you are duplicating that. So I would say that 21 is just another duplication of the lighting strategy.
Okay, so that's not necessary then. The construction ecological management plan, does that include specifics in terms of badges? What does it do you have the core document reference for that? Yes. Thank you. (116), did you say? Oh, yeah. It's not on the core document. So that covers well, the first document covers many of the things like not having chemicals to be knocked over and things like that. And then this one refers to appropriate mitigation measures required to be constructed within the CEMP.
It needs to mention because it was an appendix to it, wasn't it?
Yeah.
It needs to say and appendix. It was separate, wasn't it? Because we didn't want people to know about it, but it's not put on the condition, is it? So the condition needs to say and appendix, whatever it is.
Just appendix 2 badges. The measures measures also set out within the page 14 of the main document. Also talks about storage and soil and that type of thing. Okay. Yeah, farmland and pond mitigation. Has this been changed? I think it was farmland and was it farmland and pond originally? It's farmland and bird mitigation.
The skylarks are dealt with in the ecological management plan. Sure they are.
Right, we can't have a condition that's referring to a legal agreement.
No.
So what's the backstory here?
Isn't it dealt with in the
Where's this condition come from?
There isn't anything in the 106 that deals with any of this stuff.
It is in the committee report from March.
in the wasn't it mentioned skylarks in the ecology one?
Well, I don't understand what the first bit means. So this shall include provision of the evidenced number of skylark nest plots to be secured by legal agreement or a condition of any consent in nearby agricultural land prior to commencement. What on earth does that mean? Sorry, the officers that they just said it's come from Essex County Council, ecologist.
Sorry, thank you.
Yeah. I think it's the submission of a farmland bird mitigation strategy that there's obviously no issue with. It's the second sentence on the second.
And again, that being so, might it not be better to just keep the first bit and get rid of the second bit? Because I mean, the problem is when the conditions try to get into too much detail.
Yeah, that's yeah.
There's going to be a farmland bird mitigation strategy to be submitted and approved.
Yeah, that's it, prior to commencement.
or something similar, you
Yeah,
know.
all you need to say is prior to commencement of development, the farming
Yeah.
mitigation shall be submitted and approved by the local planning authority to compensate loss only farmland bird territories. Full stop.
Full stop.
I mean, you can say including skylarks. if
We
you
could
want- if you want to
mention
say including-
skylarks for clarity, maybe, but
That's all it needs to say.
yeah.
For clarity, we need to take out the and, otherwise it's not very clear in the title. So it says farmland bird rather than farmland and bird mitigation.
Yes.
Yeah,
Farmland, yes, quite, yeah, exactly. Farmland
Farmland
bird
strategy.
mitigation strategy.
I think, ma'am, we're dealing with the same issue where there's lots of elements on the ecology management, and this is another one. So where this is dealt with best as a relatively short condition, saying there'll be an ecological management plan to be
Yeah.
approved, etc., and then quite a detailed informative, setting out all the matters
we
that
don't
should
do
be.
informatives.
Oh, okay.
No. We
In
don't
which
do
case,
reasons
but
either.
we need some sort of direction as to what needs to be covered in that management plan, because there are matters of particular concern, such as, I mean, this is ground nesting birds, really, is what the concern is here.
Right, I think it's this the part that is problematic is this shall include provision of to be secured by legal agreement or condition.
I mean, that could be,
So, I mean, I think
Deleted.
the content shall include the following. Were you able to check it is from Essex County Council? The college is, yeah.
we've got no objection to the A to D,
A to D,
points.
yeah.
So it might just be a question of just getting rid of the second sentence.
Okay. And then 14, where you say prior to slab level, what?
Yeah, it needs rewording. Like at 15 begins, no above ground new development shall commence. Something along those lines. Yeah, so it's taking that trigger, putting it into 14.
Just on that one, Mum, I'll need the, as we spoke about previously, the reference number
Yeah.
updated again. Yeah.
February 2023.
That's right.
I've just got a question, really, why it's triggered by slab level. Why shouldn't it be pre-commencement? Because once you're doing, below slab level, you're still doing disturbance to the ecological value of the site.
Yeah, well, that's why I'm wondering why it's been drafted like that.
I think it's also from Essex, or I don't.
Need them beaming in from Chelmsford.
It's exactly not far away, really. Yeah.
Oh, you are?
Yeah. I mean, we've got no objection to it being either, to pre-commencement rather than pre. But I mean, whatever they consider to be necessary in terms of the trigger.
I think it would have to be a pre-commencement.
Yeah, I think that's right. So that's probably a bit of a. Yeah, pre-commencement.
Okay.
Any response from the ecology, it would seem that they've sort of picked holes in the plan that was sent in the ecological plan. And I think what this maybe needs to be looked at around condition 12, because basically you're just saying that it's part of condition, it's part of that condition, isn't it? It's actually looking at implementation of that condition. You're saying that, well, so what condition says action required in accordance with the ecological appraisal recommendations or mitigation measures, and it carries on, doesn't it? The appointed person should undertake all activities of work to be carried out in accordance with the approved details. So how is that then different to the biodiversity enhanced layout? So then that may need to carry on and say, maybe B, that says that any enhanced, but any biodiversity enhancement layout needs to be undertaken in accordance with that. Otherwise you're splitting that up, aren't you? Really, it's.
Can I just check the date of that consultation response?
3rd of August 2020. It's the 14th of March 2023.
Oh, so they have taken into account the latest one. Okay. I've noted what you've said there about potential duplication.
It just seems to me that we're sort of fragmenting it all too difficult. And then I also worry about discharge of conditions. Then, if it all becomes too fragmented, we get into all sorts of problems of discharging and implementation. And then that's when you start to lose things during the construction phase. And it isn't easy for the developer to understand what's going on either.
Okay. 15, noise protection scheme. Submission to the council. No issue with that. Is part C of that necessary? Because your the requirements are set out in A and the requirements are the requirements, why are you then setting out what might happen if that condition's not met?
During the application phase.
It's our fault, this one.
It is definitely. I think your requirement was the fact that because there was that issue with, actually, I think we resolved in the end of the, I think there's one unit during the, quite late in the development that we had a problem with. And I think that it was then thought if we had the additional condition, I definitely think it was you that came up with this condition.
Yeah.
I mean, I'm happy to take it out, but that's why it was put in. I remember that, but we
Well, if
put it
you've
right
got a
in.
condition requiring noise measures across the development,
Yeah.
and
I
you
think it makes sense.
Yeah.
I'm sorry.
Right.
That's fine.
I think
It is,
C's got to go, even if it
That
was our
my
idea.
request,
Brilliant
though.
idea, I'm sure it was at the time.
I'd happily remove it. I think because we resolved the problem anyway before we got
Right.
to committee, so I'm happy to remove that.
Thank you.
okay. 16, landscaping and ecology management. Sorry, explain to me the difference between this one and the ecology one we've already had. Well, so 12 is all the actions and mitigation. And that's just the management, okay. How is that going to relate to this part of the site that's covered by the 106? And do you need something within the 106 that duplicates this for that part of the site?
There is a management plan part of that as well. So in terms of we've created a new Schedule 10 that sets out requirement to manage that part of the open space.
Yeah.
In accordance with these types of,
yeah.
Okay, fine.
So there will exactly. There's essentially a duplicated process for the western northwestern bit.
Yeah, the last part again, details of legal and funding mechanisms is not appropriate for a planning condition.
Yeah.
If it's all covered by the 106, why have you got it as a condition?
There shouldn't be in there.
Well, the 106 is a management plan for the western area that we've been talking about, the blue line bit.
But not for the...
So there is that. There is also, though, I wanted to ask about this because it's something to just touch on now. There is an open space. It's a bit different. There's an open space schedule that relates to on-site open space.
Yep.
All green areas of all sorts, and that requires the 106 requires a management plan covering landscape, biodiversity and arboriculture, and then management measures. I'm sure to summarize, I mean, this is in a version of 106 you've actually seen. This is in Schedule 5. So I don't know the extent to which there's crossover between Schedule 5 of the 106 that deals with the open space management plan that has to cover things like landscape, biodiversity and arboricultural considerations and a management company and all that stuff, and the LEMP condition. Clearly Schedule 10, the new schedule that you've not seen yet, which covers the western area, we need that in the 106 because that's off-site. But so far as on-site, I think there is a risk of some duplication, but I don't know whether the council has in mind that they're for different, these things are for different purposes. There does seem to be some overlap at least.
The 106, I mean, the 106 and the condition should work together. So, and the 106 should deal with things that we can't do by condition.
Well, the bit that you can't do by condition is under H.
Yeah, so that's what I'd say. So the LEMP is required in terms of just the landscape ecological management plan should be submitted and approved in writing by the local authority, and should be, you know, there needs to be some, and what happens next. And then basically it needs to, I don't think you need all that detail in there because that is just a matter of fact, isn't it? And it should be implemented in accordance with. So 16 should be submit and then implement in accordance with, and then the rest just needs to come out. Because within that LEMP, you'll have description of features, you'll have ecological trend, you'll have aims and objectives, you'll have all that will be in that anyway. It's almost an informative within.
I see. Sorry, I've just seen. Yeah, absolutely, you're quite right. And then
it basically needs to be submit to, and then there needs to be which is some, and then the next stage should be an implement in accordance with.
And so, then the inspector's point at H, that is where the baton gets passed to the 106 because the Schedule 5 deals with ongoing maintenance and management. Yeah.
So you don't need all that middle bit. We need a conversation with ethics place about condition writing. It's just abysmal. It's just like.
Yeah, I think how you phrase that there isn't correct, is it? On the last sentence, the approved plan will be implemented in accordance with the.
Yeah, that's basically, isn't it? You need the last sentence of that bit and the first bit, and then you've got it. You've got the position correct.
Drainage. 17. Maintenance and responsibility of. Don't have any comments on that. 18. Full details of hard landscaping. 19, is that referring to the
acoustic.
yeah,
Yeah.
does it need to be a bit more specific? It says boundary landscaping. And boundary landscape concept study document, is that an actual title of something, or is that?
So have we got a document for this already? Is that picked up in, hold on, is it a document already? Because it would be picked up in here, wouldn't it? So do we actually need this condition? I'm looking for the condition. It has to be a condition, it has to be a plan we said submitted. It's there's site boundary treatments at there.
Surely you need something specific dealing with the acoustic.
Yeah, I think there is a. I think there's one of the boundary treatment plans has got it on, so it just needs. You might find it's picked up in 2 anyway.
So there is a document. It's in the core documents. It was a document that we prepared additionally to demonstrate if we went to committee, the landscape treatment of that boundary fence to ensure that it was going to be appropriate.
So do we say that? So you need to refer back. So with that document needs to become part of the plan documents, isn't it, on condition 2 then?
If we're going to refer to it in a condition, then yes, I would say.
Well, I need to know, because basically it just says the development shall be carried out in accordance with.
Yeah.
So as long as it's within, if it becomes a plan number in 2, then you have to implement it in accordance with, so it doesn't require a separate condition.
Yeah.
And that's the easy way to deal with it, isn't it? So that's the most effective way of dealing with it, because it's then just picked up with a standard condition.
So sorry, repeat that, what you said.
So there is a document that's been produced
Yeah.
as part of the appeal. Well, actually, before we got to committee, that shows the acoustic fencing that's going to go along the A127 and the additional planting. So if that is a document that's already with the planning application, then that should appear as a plan number in condition 2, and then it's picked up automatically by condition 2, because what that says: development hereby permitted shall be carried out in accordance with the following plans. So if it forms a part of that, then you don't need a separate condition for it.
Yeah, but this is requiring the full details associated with that. So it's.
Is the full details on that?
Document 2.4.
It's details.
To say building upon the details provided within that document. So I think this is a separate condition dealing with the acoustic barrier. It's not specifically a landscaping.
Oh no, it's just
I've got a point on the wording also, ma'am, just to throw something else into the mix.
Yeah.
It says the scheme to be implemented prior to occupation and then thereafter permanently maintained. I'm not sure how they could permanently maintain it prior to occupation. So I just wonder, that's conceptually quite hard. How could that be enforced?
So what are you suggesting as a?
I'm not sure I have a solution, but I just thought that was difficult for them to discharge. It's either prior to occupation or it's an ongoing condition, presumably.
So there is a document CD2 looks at the additional and the boundary landscape concept study. So it needs to be implemented in accordance with that, and then we need additional details of planting.
We've got a document. Technical detail.
This is a concept study. This isn't
Oh, no,
something.
no, no, that's, I know it's not the details of that, but it's, that's what they've looked at for the noise, so that they have to implement that in terms of what they need, but we need the full details of it. Occupation, full details of it, so occupation, full details of the development landscaping in accordance with. So your noise work is based on that, sorry, your noise work's based on that study, that document. So what we don't want is another set of, because what we don't want is that, what I'm worried about is that if your noise assessment's been based on that study that you submitted with that work,
So
then we don't want to be submitting a new, it needs to be implemented in accordance with that, because that deals with your noise issues. But what we haven't got enough is enough detail on that. So we need to, that would be the starting point. So then we need further details of how you're going to implement that.
that's fine.
Otherwise, we're going to, because what I don't want is that we have a document to deal with. We've got your noise acoustic stuff, which is part of that document.
Yeah.
And then we're asking for additional landscaping.
Yeah.
So, but this condition needs to refer back to that as a starting point, then ask for further details, isn't it?
Which we're happy with.
Especially looking confused.
I know.
It is, I mean, because otherwise, if we ask for separate details, then we could be asking for things that then wouldn't mitigate the noise, and then we're going to get into a real mix.
I don't think it's separate details. I think it's because it's referred to as landscaping. That's the issue. It's more than landscaping. It's
Yes,
a
but
noise
yeah.
attenuation.
Yeah,
Yeah.
but that's set out, so the intentions are set out in that document of what it has to achieve. So basically, we're saying that prior to occupation, full details to implement that scheme need to be submitted to the council.
This is not
That's what it is, isn't it?
dated.
It's an
This
implementation
document, is it?
details.
A date on it.
We did. Strange. Yeah, 127 boundary landscape concept study, which should check that. There's no date.
There's too many conditions in the same thing. Well, that should be part of the landscaping scheme then. You shouldn't need a number of. It's probably on too many things to go wrong. Yeah, but a landscaping scheme, that's hard on to anyway. It's off landscaping.
Does changing the second bit to in accordance with the approved details and permanently maintained thereafter address the point that you made?
So my point was, it's a prior to occupation condition.
Yep.
And saying and thereafter permanently maintained seem to be a separate obligation that you can't fulfill prior to obligation because it goes on beyond prior to occupation. Maybe it's just a matter of saying to be thereafter permanently maintained. So that goes to the intention that you submit prior to occupation rather than what happens afterwards.
Mrs. Spector, I think, you know, honestly, I think this condition is completely pointless. There is a soft landscaping condition at condition 20. And then we've got a separate condition that deals with noise mitigation on the A127, which already picked up. So really, actually, it's a superfluous condition. Because we've got a noise condition that deals with the acoustic fencing, and we've got a soft landscaping scheme already. I don't know why we've got additional condition that deals with A127 landscaping. It just seems to be a little bit, there's too many duplications then.
Okay, and then rereading 20, there's also an issue about the period within 5 years isn't addressed by this condition, the landscaping on the boundary treatment, which it would need to be.
So my suggestion is that we take out condition 19, we use condition 20 and then 23 deal with this problem, because they 20 deals with landscaping per se, and condition 23 deals specifically with the noise mitigation on the A127, which is what we want to get to. Otherwise, we're going to have three conditions trying to deal with.
Right, but the specifics of 20, the benefits I think of separating it out are the specifics of 20 are talking about drought tolerant planting. And obviously the boundary landscape concept study already indicates the planting that's going to be down in that area in and I think the thereafter permanently maintained rather than the trees or planting within a period of 5 years shall be replaced. I think that's slightly more appropriate given that's a boundary treatment.
There's also a tail piece. Again, we need to have a full stop after species and take out unless the local planning authority gives written consent to any variation, I think.
On which bit, sorry?
On at the end of B,
yeah,
there's a tail piece at the end.
Delete that after species.
Yes.
Yeah. Because I think it is an entirely different entity to the remainder of the site. I'll take away those comments you've made on that. So 20 requires
Tail piece.
scheme of soft landscaping. Council's pollinator action plan, is that? There is one of those, is there?
There is, yeah.
Okay, 21 we've already addressed. 22.
That's got a tail piece again. Shall be submitted. Oh no, so say B's got a tail piece at the end. Just permanently retained, full stop.
And then noise mitigation. So this is dealing with noise in relation to existing residents around the development and proposed residents. According to the reason that that's been given there. So there's specific mitigation measures in relation to neighbouring residents. Is it just the acoustic fencing? Anybody help with that?
I think it's just it should just be proposed, Mrs. Inspector, to ensure the proposed residential properties and other noise sensitive premises in the vicinity. This is to do with the noise in A127. This is mainly to do with that issue. That's the main noise receptor is from the A127. So that's what this condition is there for, to protect. So actually, it should just read the reason to ensure the proposed residential properties are adequately protected from noise.
So development hereby permitted shall not be occupied until those measures have been implemented, inclusive of the acoustic fence, and then the part about should mitigation include, that can be deleted. Is that what you're saying?
Yeah, that's dealing with, that's not, this is that would deal with a matter if you had a ventilation system over a shop or something. You don't need that.
I mean, there are no noise sensitive premises in the
No, there aren't,
vicinity.
no. Yeah.
23. Car parking and electric. Oh, is it? Sorry. Okay.
Yeah, because B is picked up by building regs.
What does active electric vehicle charging points mean?
Well, you have either passive or active, don't you?
Oh, I
So,
see. Okay.
but isn't that picked up now by building control? So, but the building regulations pick up B now. I think this is probably this was probably drafted before the changes. So it's a building control requirement. So actually would fall away from planning now. So we don't need B. We need a parking strategy, exactly right, but we don't need the vehicle charging point position.
Okay, cycle parking, is it possible to specify the actual plan there?
It's on here.
Is it on the general arrangement plan?
Haven't got this one. New flats. So that's also parking them.
I don't think it's marked on either the general arrangement plan or
We just
the,
looked at it. It's not, is it?
So you
or
need
the
you
parking
need
plan. So
a
we need
scheme
we need
for.
a scheme, yeah.
Yeah. A scheme for cycle parking facilities. Guided and implemented.
Ma'am, just for reference, there is a reference in the transport assessment, paragraph 9.6, to car and cycle parking for the site to be provided in line with the latest EPOA standards. I'm not sure precisely what they are, but I think there might be need to cross-reference since that's what is included in the transport assessment.
Okay. Okay. 26, energy and sustainability. What's the point that you were making earlier in the week about gas boilers? So a reference to something there.
That's a question.
Is it, sorry, was there an issue with the gas boilers point earlier on in the week, or is that?
No.
No. Nobody has an issue with that,
no.
okay. And this would have to be and permanently retained, wouldn't it? Those approved details. Is that a condition that's necessary if it's in line with the future home standards?
And I think at the moment, that's not what the future home standard is. That's coming in 2025.
Okay.
So there's not a requirement. I do have a question about enforceability, because I mean, what is there to stop an owner of the property just reinstalling a gas boiler?
Yeah. Sorry, what's the policy basis then for this?
There's no planning policy basis for it. The policy that relates to our climate change as a council position. So we haven't got a policy position on it. But Bloor Homes were keen they were keen to see no gas development.
And just on Christine's point, there is always the issue about time limits on enforcement anyway. So, you know, there could be a question that, you know, if it's 10 years after it's been installed, you know, whether there is any means to enforce against the sale of that property. You know, it's kind of hypothetical, I know, but it seems to present one or two difficulties.
Can you just remind me, is there a sort of energy sustainability statement with the application? I'm assuming there must be, because the condition's talking about location and quantum of photovoltaic panels and air source heat pumps.
I'm not sure there's a separate document, but there is a section in the design and access statement to which it relates, which talks about energy efficiency, service order management, etc., and sustainability measures.
I'll have a think about that. Okay, 27 is bird and bat boxes. And 28 is the residents' travel plan measures. Is that necessary on the basis that that's within the 106? Okay, Dunton Road access works 29. This is slightly different to the as drafted from Essex County Council, isn't it? So I need to understand what's happened there. Looking at the one that's contained within the Statements of Common Ground. Right. So Mr. Simons, what was his name? The sustainability transport witness, Mr. Walton. He's not here, is he?
Not here today, unfortunately.
What do you need to?
So the condition has changed from the committee report to what you're seeing in front of you now, effectively.
Well,
Condition
and what-
29.
But it's not in accordance with the statement of common ground, so we need to understand what's happened.
And we've got a condition that basically was, ACC provided us, but then the statement of common ground between the appellant and the highway authorities changed that.
The statement of common ground, of course, with ECC is
Yeah.
more recent,
Yeah,
and so
It doesn't look like this matches the statement of common ground either, does it, at the moment?
what doesn't?
Condition
one.
29 is drafted.
No, doesn't know.
but it should, shouldn't it? Because I mean, I mean, we can check this morning, just give them a buzz.
Yeah, we'll give them a call.
But I would assume that unless ECC have made an error, which we'll check, but the one that ECC are content with in the most recent version of the documents should be slotted in. But
I'll give them.
I'm just going to email him.
we'll check that now, Madam. If you have an answer, yeah, I think he is at the end of a phone
Okay.
for this morning, so we'll
Okay.
hope to have an answer quick.
Is it Miss McLennan? Sorry. Yeah, I think I indicated to the office to Mr. Dadds that we might be on site about 11 to 11:30. So, okay, thank you.
More conditions than we
Optimistic as
thought,
ever.
yeah.
So you're trying to sort this out
We'll
now.
confirm
Then
that, yeah.
Now, yeah.
bus infrastructure enhancements. That's the upgrade works to Dunton Road.
The typo there, man, at the end.
Yes. Yeah. Um, 31 air quality monitoring. Right, why is this difference to 32 to the existing SUDS condition? Because surely if you're requiring something as part of the maintenance plan, then it's required.
Mr. Hargis has got a good point. I think, ma'am, that just because it's being monitored doesn't mean that the amenities of anybody is protected. Well, it could lead to that, I suppose.
So what do you mean amenity?
Oh, so just looking at the reason it says it's to be monitored to protect the amenities of existing and future residents, but it's not clear what's going to be done with the monitoring. Perhaps it's obvious, but I think his point is.
Sorry, I've
it's
moved
good.
on to 32. So
Oh, I'm sorry.
no, it's okay. So
Yeah, that was for 31, air quality monitoring.
what are you suggesting in terms of the condition then?
I suppose the matter of question is, why is the monitoring being done, and what is it going to be used for? We haven't got any evidence on that as to its role. So, you know, if it's being monitored and is found to be below a certain standard, there should be an action. You know, and if so, what sort of action is a practical action, given that we're going to have 269 occupied houses here? I'm just trying to see how this is taking anything forward.
Yeah.
Yeah, I mean, is it necessary? I know it's a worthy. I know we're trying to protect air quality,
Mm-hmm.
but I don't see how this condition is necessarily helping us.
What's the policy background to 31?
Well, I mean, sort of management like
Yeah. I think there is a point here that it is a noble, you know, perfectly. I mean, the aim's fine, but it doesn't really go anywhere, does it? You do monitoring, and then what? And then what?
Well, it says a strategy for ongoing monitoring.
Yeah,
So if there's a policy requirement for,
it might be set out somewhere in the policy.
yeah.
Yeah.
Is there a policy requirement for air quality monitoring?
This is a duplication of condition 39. Development shall be carried out in accordance with the recommendations in the submitted air quality impact assessment. The construction phase methodology mitigation should be employed accordingly. So it's actually picked up in it, and it's a duplicated condition. So basically, it needs to come out because 30.
And that 39 includes the monitoring, does it?
In accordance with the construction phase methodology, mitigation should be employed accordingly and retained.
Is there a policy requirement for air quality monitoring in Basildon?
We haven't got any modern policies at all, so there's no policy for us to look at air quality. There's a corporate policy, obviously, in terms of the DEFRA air quality management direction. But that's to do with the road, the A127, not specifically to do with any residential sites. So condition 31 actually isn't. I would say it's not policy compliant. But condition 39 is about looking at the recommendations set out in the air quality impact assessment submitted by the applicant, the appellant. So 39 would be justified, but 31 wouldn't be justified.
Okay. So 39. Why is there the maintenance plan? Why is there a subsequent requirement in terms of that and a yearly maintenance log? 32. Yeah, it's 32, sorry.
So this has been split up. So condition 17 deals with the drainage maintenance plan. So really the yearly logs should fall as part of that condition then. You're asking the private occupation, you're asking them to deal with it at that point. Drainage maintenance should be carried out there in accordance with the approved details. And you could end up with a C that would then say that yearly log should be submitted to the council.
The maintenance plan, including the activities and frequencies, is going to be set out in that, isn't there?
Yep.
And actually, rereading, sorry, I should put this up earlier, details of long-term funding arrangements cannot be included within a condition.
No. It should only probably be maintainable by the maintenance company.
Then, sorry?
Yeah. Sorry, I was reading out loud, sorry.
So you're requiring a maintenance.
Shall be approved of the planning authority. That should end there, shouldn't it? And then actually you don't need the next bit, because then the next bit says drainage maintenance should be carried out thereafter in accordance with the approved details. That's all you need to say, isn't it? And then
Yes, I don't think requirements for a yearly log, because that whatever you specify in terms of the maintenance arrangements are going to be covered by 17.
Yeah. So you wouldn't need condition 32 could be withdrawn then, yeah.
33 I do have an issue with. because I don't think that's enforceable.
Should do this by, it should be done by 106 agreement, shouldn't it, actually? Yeah.
Unless you're going to tell me you have a policy which has a,
No, we have no policies on this inspector. This should actually be a 106 obligation rather than a planning condition.
well, I'll leave that for others to
Yeah.
think about.
You don't need this.
34, the 10% of the units, is that not a building control requirement then?
That is, yeah, we don't need that. And we haven't got policy for that anyway.
And it's same with water efficiency.
We're asking for the enhanced version here, aren't we?
Yes, the optional requirements
Yeah.
already condition.
We're asking for the optional requirements for this. Again, Mr. Inspector, we don't have policy requirement for this, but this allows us to ask for the improved water requirements to reduce water usage.
.36 secured by design. Yeah, this part 37 time limits. Before further surveys are required.
It's fine, yeah. But you can't use informatives.
Isn't there a requirement within the the mitigation reports for the surveys to be undertaken anyway?
Very helpful.
But they will all be subject to appropriate time limits, wouldn't they?
Does this come from thingy? It's come from day services.
I'll leave you to come back on that one.
Yeah, okay. Just check that.
Construction hours, I don't have any issue with that other than the latter part, other than internal works, because if you've got a restriction, it is a restriction. Any comments on 38?
Can we move that into condition 5?
Can you, did you say?
Sorry, yes, because I mean it would just fit in then with the construction management plan, wouldn't it? It would then all fit into one one condition.
I think it's well, you would require hours of construction, then you wouldn't, I think it's probably preferable to put those on from the outset.
Yeah. We can leave those conditional, we could go into that. I mean, that's they'd need to submit that all together, wouldn't they, as one document?
Okay, 39 air quality. I think we've covered that, haven't we?
Just for clarification, ma'am, I was just checking what those mitigation measures were. They're in Appendix E, and they're just dust mitigation. So it's really a construction issue that's being referred to there.
Within that report.
Within that report, and therefore that condition.
Okay. $40, I mean, you're going to enforce that.
It's a matter of ecology management, isn't it?
Oh no, it's all over the place. Yeah. So that condition would need to stand then. Yeah.
And similarly, 41 is surely already covered by the BAT.
Yeah, but yeah.
Yeah.
It's under 37. The report is already timed. It's got a time limit anyway. The report lasts for 12 months. So in terms of condition 37, the time limit on ecological surveys only lasts for 12 months anyway. So they'd have to redo them.
Yes, yeah.
As a matter of course. So I don't think the condition is really required then.
Ma'am, just a quick point. The condition 41, it says no tree works during December to March. I know it's going to get striked off by the sun, but that would be the opposite of the bird nesting season, which is March to September. So what it's saying there is wrong. Tree works can happen between December to March. They've got it.
Oh, they've
it's
got it
the wrong way
incorrect
around.
anyway. Right, okay.
Yeah.
Okay, and 40. So, Mr. Fisher, is there another one that you're coming back to me on? Yeah. Okay, still checking that. Okay. So 42, I think we've already covered. 43.
It's got commuted some requirements. That's incorrect.
Also, I was wondering about the necessity of this.
Yeah.
Because
if it's within the highway, if it's creating a new highway that's adopted by the highway authority, they would have to agree anyway. If it's in road that isn't adopted, then it's up to the developer to deal with it at their expense. So either way, it'd either be covered by the highway authority at the point of which they would adopt the road anyway, and they would deal with it prior to adoption, because they'd agree the standard of the road, or it would be the developer's responsibility. So they would either not do, they either want highway trees or not. I think condition 43 is unnecessary.
And 44 wasn't clear as to how precise this was when it says gardens of neighbouring dwellings. Are you clear about which neighbouring properties you were referring to there?
What's it to do? Yeah, or is it existing dwellings? Is it those facing the existing? This one come from? The only issue you'd be looking at is existing neighbouring dwellings, not, because otherwise it'd be buyer beware, wouldn't it? Where come from? We've got any side on? Yeah,
So can you either specify which blocks, which properties that's referring to, or which neighbouring properties you're referring to?
Yeah. On the flank. Why has it got apartments?
Ma'am, I was just thinking as a general principle, clearly there can be slight changes to the layout, subject to approval and so on. So the condition here is more setting what the principle is that needs to be addressed. So if there are future changes, that this condition still applies. If you name the blocks,
Yeah,
they could become out of date. The condition then wouldn't be effective.
I think the point is though, it's why is it, from my perspective, it's why is it there? Because if it's within the development, then all the development itself should prevent overlooking, so we wouldn't have approved it. My only concerns are relating to the existing properties in Steeple View, but the garden depths are larger than we require for that condition anyway. So whether or not it's reasonable.
who's come up with that? Okay,
This side, northwest is this
Mr. Hodges, I'm thinking through your point, if there was an amendment, then it would then be approved and then they could subsequently add a further condition on, couldn't they, to that effect? I think at the moment it's too vague.
I mean,
Gardens.
I would say the garden, sorry, Mrs. Inspector, the garden depths on existing properties are, we would not normally put that condition. We'd not normally use that condition because the existing garden sizes of the current properties where Mr. Humphries is talking about are too long. So I'm a bit, I don't know why I put it on. No. So it's over here. Oh, this is yeah. No. From a point of design, I'm content to remove it, Mrs. Inspector.
From at what point?
I don't think it I'm not quite sure what it's supposed to be achieving, and I don't.
Preventing overlooking, isn't it?
I can't see where though.
Okay. Sorry, I don't know the officer's name up there. It's Mr. Humphries. Mr. Humphries, are you looking at which?
No.
Will be higher. Yeah. Yeah.
I don't either.
Some front windows there.
I could probably get that one down there.
There was also some front windows in the apartment.
This one down here.
Yeah, so just whether that was a concern or not.
To that one.
To to these gardens.
Oh,
And the
I
flank
see. So it is in relation to existing.
Existing and proposed, so those neighbours. The windows at first and second floor level. That one, that one. The rest of the two-story house.
Sorry, do they have my eyesight's not that
Sorry.
good. Do they have a block numbers?
They would do, I can find them.
Yeah.
Is that apartment block in the south eastern corner then, is it? That's overlooking the farmyard?
No, it's an internal issue.
Yeah. Yeah. So we just restrict those to 2 plots then, to 2 plot numbers.
It's going to
Yeah, okay.
confirm which ones were meant. Sorry, plots 24 to 29. '84 to '89. Sorry, are you saying block or plot? Block. That's block, but the first one was plot. Block. Okay, so that's my mistake thing. And the 232 to 237 is to do with internal overlooking within the development. Potential for that. It's not an external neighbouring properties yet. And I've noted the residents' point about the wider blocks, the wider issue. Okay. So we're just going to come back on the highway, ecology surveys, yeah. But they're valid. I think the officers confirmed they're only valid for 12
They're valid
months.
for 12 months. So basically after 12 months, they'd be invalid. So you'd have to redo them again anyway. So if you, yeah.
Okay. 29, you still coming back to me on that?
It's the highways one. It's a highway statement of common ground version. Mr. Walton's called up Essex, who are content with the one in the highway statement of common ground.
Yeah, which number? Which number condition was it?
29.
sorry, on the statement of
Oh,
common.
sorry.
5, yeah. So it's both of them are covered prior to occupation. Yeah. Okay, that makes some sense.
One more point, if that's all right. It's the plan in at condition 2. Plans condition. Okay, so on page 9 of the statement of common ground, I don't know if you've got it on the, it's about 12 plans down, also maybe 10 to 15 plans down from the beginning of condition 2. There's the
Sorry, I've got them printed out separately.
sorry,
So,
okay, so just condition 2 plan numbers.
yeah,
Then there's a whole load of them.
yeah,
But about say the 10th one or so,
down.
yeah, it should be the housing tenure plan.
Yes.
That wants taking out because it doesn't reflect the up-to-date 40% offer. That was a lower position, and indeed, as you'll see, the 106 requires a tenure plan anyway.
Okay. Thank you. Okay. So that concludes the discussion on conditions. So we'll be back here on, we'll talk in a moment about the site visit, but we'll be back here on Tuesday to go through the 106. Am I waiting anything else on that then to take away?
Well,
Yeah.
We've got to open these.
9:30, yeah.
What we've got. Run these two and then I'll explain what they are. Oh, that's obvious what they are. These are going to need to be tied into the
Do those, all right, yeah.
yeah, two. They do the same. I think we have been sent this wordings from the from the authority in respect of dealing with what we can now see as the blue land. So I think if you're, well, as you say, it's for us to propose suitable 106 plans to you, but hopefully these do the job of clarifying the different areas, and then we need to tie them in through into the 106 into the drafting, which we need to put a message that we can take to our solicitor. But that's the, yeah, that's it.
Just as a initial comment,
Yeah.
I think probably the legend needs amending, because what it's actually denoting is land required for landscaping
Thank you. Yes. I rather than land within the appellant's control.
Well, yeah.
Yeah, we will do both of that, but we'll do that on both of the plans.
So back on Tuesday, we'll go through the 106, and then I'm assuming you'll be content to move then straight on to the closings.
Yes. Well, we from our side, yes.
Yeah.
I suppose Mr. Dad should probably be told about that. I think it's brilliant.
Yeah. And I'm not going to ask for estimates on that because we kept time generally. So
No change from our side.
yeah, I don't think there's going to be any issues on that. So where should we park and what time would you like to meet?
I'm not sure we can. Not sure we can sign in respect to one of them.
Yeah, I know it's quite
It's a good idea. It's a good idea. Yeah.
Yeah, Mr. Child, I don't know if the can you bring that? Yeah, bring one of those A3s because I need to look at that.
So immediately, well, we could just. Where? Do you want to park there or there?
On the north side.
North side. So there's easy parking. Yeah. You going, Mr. Hard? I'll just show everyone. Can you see my screen?
Yeah.
So site.
Yeah.
Immediately to the north is Sellers Farm, and there's which you can park in. It's our clients.
Sellers Farm.
So at Sellers Farm, there's this sort of parking area here that's hard standing, and then we cross over Dunton Road into the site. It's immediate opposite the site, but immediately to the north of Dunton Road.
Okay, so we'll meet opposite that.
Sort of, if you can pull in here into this area.
I see your cursor. Yeah. Okay.
Sorry, yeah, I just realised that. Yeah.
Yes.
Opposite a
So
sign
we'll
to the
park in
grammar.
there and we'll meet outside that entrance. And I've got a note of who's attending. Yeah. So so what time would you like to meet there? 12:30. Yeah. Yeah. Okay. So sorry, is there another plan? Oh yeah, no, I think
I was just
thank
going
you
to ask if I was going to bring a number of plans, but obviously there are hundreds. Are there any particular plans you think you'd find helpful?
I think as I'm content with that
Okay.
the site layout, but thank you very much. So that concludes the discussions for this week. So we'll be back on Tuesday for the 106 and closings. And just to repeat, there isn't any discussion about any aspects of the case on the site visit. It's purely for me to access the site and make appropriate notes. So talk about anything else but the case. Yes, I've got mine. So yeah.
You will. That's a
Yes.
good idea. Good
Yes.
idea.
Okay, so thank you very much for your contributions this week, and the inquiry is adjourned. Thank you.
Thank you, madam.